The proposed $2.8 billion NCAA antitrust settlement faces fresh legal resistance, even after recent revisions. Objectors argue the amended deal still leaves thousands of college athletes vulnerable to losing their roster spots due to sport-specific caps. These limits, central to the agreement, are tied to schools' ability to directly pay athletes for name, image, and likeness usage, a major structural change set to take effect in July. On April 23, U.S. District Judge Claudia Wilken temporarily rejected the settlement, calling the roster limits unfair. She instructed both sides to ensure no athlete with a current or promised roster spot would lose it due to the settlement's implementation. In response, lawyers for the NCAA and conferences proposed a plan allowing schools to exempt athletes who were on 2024 to 25 rosters or had received commitments for 2025 to 26. But crucially, this exemption remains optional. The NCAA emphasized in court filings that roster spots have always been up to coaches and schools, arguing that athletes have no guaranteed right to team placement. However, objectors counter that leaving the decision to school discretion undermines the settlement's fairness and legal soundness. Attorney Steve Molo, representing one objecting group, proposed that all current athletes and high school seniors promised a spot should be automatically grandfathered in, not counting against any caps. He suggested schools retain the right to remove athletes only for legitimate, unrelated reasons, and recommended arbitration if disputes arise. Another attorney, Laura Riathaford, argued for mandatory grandfathering, stating the opt-in nature of the current fix fails to treat all athletes equally. Without uniform protections, some athletes may benefit, while others remain exposed to potential removal. A third group, led by Douglas DePepe and Robert Hinckley, supported those proposals and called for a formal grievance and oversight process to protect athletes' rights under the settlement. While Wilken seems inclined to approve the broader $2.8 billion deal, she has signaled that without a fair resolution to the roster issue, final approval won't be granted. The NCAA, conferences, and plaintiffs have until May 16 to respond. At stake is not only billions in back pay, but also the foundation of a new college sports compensation era.